Welcome to eDiscovery Leaders Live, where I get a chance to chat with luminaries in eDiscovery and related areas. This broadcast is sponsored by Reveal-Brainspace, the industry's leading AI eDiscovery platform. Don't forget to subscribe to watch me, George Socha, weekly with leaders in eDiscovery. Thank you for tuning in. Welcome to eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. I am George Socha. I head up brand awareness at Reveal. On each episode of eDiscovery Leaders Live, I get the chance to chat with luminaries in eDiscovery and related areas. Past episodes are available on the Reveal website. Go to revealdata.com, select resources, then select eDiscovery Leaders Live. Our guest this week is Dawn Poulson. Dawn is the Litigation Technology Project Manager at the law firm of McLane, Middleton. Dawn, welcome.
Good morning. How are you?
Doing great. And you?
I'm well, thank you. Thank you for having me on. It's quite an honor.
We are glad to have you with us. I'd like to start out by asking first for you to explain how it is that you ended up doing what you do and doing it where you do it.
Well, I started working at McLane almost 24 years ago, and I have always had a strong computer knowledge and strength and really thrived on technology and finding ways to do things without repetitiveness, without repeating yourself, and more efficiently and cost effectively so that we were not spinning wheels when there's got to be a way to make it better. We started out with CaseMap, and from there it just grew and to where we are now, where we are, a 100% one in-house. We have it all. We can do it all in-house in terms of finish to start, soup to nuts with eDiscovery and being able to handle it for our clients and provide high quality service and work.
Tell me a bit about your firm. How big? Where you're?
So McLane Middleton is a mid-sized law firm in New Hampshire. Our main office is New Hampshire. We have offices all over the state, and we have two in Massachusetts, one in Boston and one in Woburn. We are a firm that is well diverse, and we cover most areas of law, litigation, corporate, T&E, tax, cyber, data privacy. We do it all. We're one of the larger firms in the state, if not the largest. And it's a great place to work, and I love my job, and I love the family and the people I work with.
Well, over the years, you've done a thing or two, you've seen a thing or two, you've learned a thing or two, and there are, I know, some topics that have become of a special importance to you. Let's start with one of them, transparency.
Transparency. I am 100% a proponent of being completely transparent in everything that we do. When it comes to working with our clients, what we're going to do, and when we collect their data, to working with my colleagues and coworkers about how we're going to get from point A to point B. And I am a strong proponent of being as transparent as we can be with opposing counsel so that they know what we did or did not do in terms of what we're delivering to them in terms of a production or not producing.
Right. I'd like to step through that in three parts.
Sure.
Let's start first with transparency with clients. Well, how does that play out?
So when you're working with a client, we work with a diverse population of clients. We work with big corporates and industries, and then we work with clients that are individuals. And not every company or individual has an advanced IT department that is able to run scripts and pull all PST files off their network without you knowing. Sometimes you're working with a client that has just a personal Gmail account. And it can be quite a traumatic experience for them to have to turn over their entire email account in fear that you're going to turn everything over to the other side, or someone's going to be digging through their emails. And whether they have something to hide or they don't have anything to hide, it's invasive and it can be very uncomfortable. And earning that trust with the client is so huge. And, you know, reaffirming to them that, hey, we got your back. We're going to protect your data. We're going to protect you. Nothing's going to get turned over that's going to embarrass you. That's not really, anything, just I think building that trust with the client is so huge. And holding their hand through the process, because it is a bit invasive. I mean, pardon me for saying, but it's kind of like someone going through your underwear drawer. You just don't want anybody there. It's private. So I think it's, being transparent with them, letting them know exactly the process, letting them know exactly what you're going to do, and and explaining to them that nothing's going out the door without the attorneys laying eyes on it. And and we oftentimes let them look at what we're going to produce. So that, I think, being completely transparent with your client, especially with regard to data collection. I mean, let's face it, when you're in the middle of a litigation, you got two parties that disagree. So, there's already some animosity forming. And so, building that trust with your clients is so important. I can't stress that enough.
What are some specific strategies that you've found to be most effective to build that trust with the clients, especially the clients for whom this is a new and scary thing?
So, we try to we work with the clients and explain to them, look, it's part of the process that we have to preserve your email accounts. If you have any communications in your email that are at all related to this matter, we have to preserve it. And as your attorneys, it is our obligation to preserve this for you. If you let us collect it, we can just lock it down. We may use it, we may not use it. If we are going to use it, we are only going to apply these search terms within this state range. Any communications that you've had with us, being the attorneys, they're not going anywhere. Nobody's sitting there sifting through your emails and going through and reading them all. Nobody cares about, your pet's doctor's bills or anything, your trips that you're taking or anything else that may be there. And then, we have oftentimes even provided either to them the documents we intend to produce, or maybe an Excel spreadsheet. If it's too voluminous, we can give them an Excel spreadsheet that has all of the specifics, and they can go find them in their emails. And that usually is enough to alleviate some of the nervousness that they have. We've offered to, at the end of the case, delete it and give it back to them so that they know we no longer have it. And in terms of, trying to collect it, of course, that means, you got to turn over your password. Sometimes we'll say, if you want, why don't you change your password to something else? And then when I'm done, you can change it back. I have no interest in being live in your email. And if you saw the amount of data I collect, I truly, it's just to protect you and to protect any claim that we may not have collected what we needed to collect.
At times, and I've encountered this situation, clients can have in their work email content that is, to say the least, highly embarrassing.
Absolutely.
And it can be so embarrassing for them that they end up putting up all sorts of barriers to prevent you from getting to anything. So that's like one of the worst case scenarios. How do you help ease that process along for them?
The attorneys usually step in at that point and, and reassure them that anything that you say or have that we see, no judgment, right? And we've got your best interest at heart. And even if it is something that's there that could potentially be embarrassing and or could be related, because sometimes those embarrassing things could be at the heart of the matter, the it is at our client's best interest and our best interest that the attorneys need to know about it. they need to know about it, because if they don't know about it, the worst thing that can happen is being told in the middle of a deposition and it's being thrown out as an exhibit and you're caught unaware because you didn't know. So knowing more up front is better than not knowing at all. And the clients usually have high respect and regards for our attorneys, and the attorneys in our office handle things with very discreet and discernment. And if there's any way that we can protect it and prevent it from moving forward, we do sometimes. But it is what it is sometimes.
Let's move now to the next area of transparency that you mentioned, which is transparency with your colleagues. How does that play out?
Sometimes well, sometimes not so well. There's a process and there's things that we need to do. And, I am totally upfront, and if someone wants to shortcut a process, sometimes you have to step in and say, kind of that's not like the proper way to do it, and explain why. But over the years, we've built a trust, and that trust is there, and that trust is, it goes both ways. And, being transparent with them with regard to how long something's going to take to get done, transparent with them that, we may consider other areas of data repositories that we might need to collect, being transparent on, how long it's going to take to do a production. I mean, just because it's electronic and it's with these fancy tools doesn't mean it happens any faster. But over the years, that trust has been built, and it works.
I would imagine that history of trust goes a long way to explaining one of the things you mentioned at the beginning of this discussion was that you as a law firm are doing all your e-discovery work internally rather than parceling it out to others. How much of that is built out of that trust? How much of that comes from somewhere else?
I think it comes with the fact that we love to provide the best quality service to our clients as possible. And if we're able to save them money by doing it in-house, and it's more economic to keep it in-house, we can do it. You don't there are some instances where you have to retain a third-party vendor, but if we're able to do it in-house, we will. And it's meant to provide the best client service that we can offer to our clients. And keeping it in-house, I think, oftentimes streamlines the process, and it also makes us completely available at all times to be there for whatever is needed to be done.
So I'd like to come back to process in a moment, but before we get there, we've got the third area of transparency, the one that I think is the most challenging, and that's transparency with opposing parties. How do you deal with that?
We deal with it well when we're working with, especially a large data set. And, the client doesn't want us to review 500,000 emails. I don't think there's anybody in the office that wants to review 500,000 emails. And I can't imagine any opposing party would want to receive 500,000 emails. So if we're going to run search terms, if we're going to streamline the custodians that we're going to collect, or we're going to limit a date filter, disclose it. And one of the tools that I think is the best way to do it is taking advantage of the discovery plan and implementing an ESI protocol. If you have both parties come to the table and you're able to put together an ESI protocol, you can pretty much nail down the who, the what, the where, the how, all spelled out. And there's no surprises. I mean, granted, as time goes on, different issues come up and different search terms might need to be applied, but you can indicate, who your key custodians are and agree on it. You can implement search terms and agree on it. You can implement a clawback. You can say, we're going to do a date filter. We're going to mainly focus within this date range in an effort to streamline it, find exactly what you need, I mean, you can even put in there, how and what is going to be logged on the privilege log. And if everything is out in the open and everything is agreed upon by both parties, no party can claim foul. And as you know, and everybody knows, there aren't judges that love discovery disputes. So if you're able to resolve the issues up front, I think it saves so much trouble down the road. I mean, inevitably, there are going to be those times that you are going to have to go before a judge because they're not going to get resolved. But the more that you can resolve and agree on both parties, I think it works well for both parties and the clients, both sides.
It sounds like you've had very good success then with this approach of marrying transparency and ESI protocols.
I think so. And we are, as a firm, really trying to really get everybody involved in that. And I think having, myself and technologists and people that really understand the language to review those ESI protocols. I mean, there are times where I'm pulled in to the conversation with opposing counsel, and it's kind of like, all right, let my people talk to your people because they talk a language that we don't understand. Or there's times where attorneys will forward me the ESI protocol and say, hey, can you read this over and make sure that we're not doing something that we're not agreeing to something we can't produce, aren't willing to produce, or, heaven forbid, they sign something not knowing that we just agreed to an entire native production. So if they don't understand it, they have me look at it. And I just think that so much can be, you're still going to bicker back and forth. There's still going to be issues between the parties. But a lot of it can be streamlined. And then I think that limits the type of disputes, the discovery disputes that could arise. If it's all spelled out, nobody can claim foul.
What are Although it sounds like this process has worked quite well, of course, invariably, you've run into situations. I've got to imagine you've run into situations where there have been bumps along the way. What have been some of the biggest types of bumps along the way, and how have you dealt with them?
I think a lot of the big bumps that we run into are working with firms, and by no means is this, an insult to any firm at all. But some firms just don't have the technology or the pro- or the products available to be able to produce everything in the format that we want to receive it. So we still can get ginormous PDF files of everything scanned together. And, sometimes we even fight, you have issues where attorneys aren't they're not producing attachments, or they're not producing metadata, or and those types of battles back and forth. Or, they want everything natively, or they want you to search terms that are just completely unreasonable and not proportionate to a case. So those are the types of bumps that we run into. And, I think the attorneys handle them very well. They're very well versed in, over the years, I think I've done enough diagramming and drawings to have them try to understand the process, that they are able to stand on their own 2 feet and work these things out.
Well, let's then step back to process.
Okay.
And then, well, how do you approach the whole process of e-discovery?
So the process is how you handle e-discovery or ESI from the time you collect it, or even before, when you identify it, all the way to the time you get to the trial. So the whole life cycle of the data that's involved, and understanding the level of it depends on your role. So how deep in the weeds do you need to go? As technologists, we need to know it all. We need to be able to explain the whys of everything, because if you don't know it, someone's going to ask you, and you need to be able to explain it. And on an attorney level, though, they need to understand the process. I mean, it's in today's world, in technology today, we have these products that kind of do it all for you now, and you upload data and then it spits it out and it's all done. And if you don't understand the process, truly that product is only as good as the box that it came in. Because if you don't know the process and understand the process and something goes awry, you don't know where to start because you don't understand, did something go wrong in the beginning when we collected? Did something not get mapped properly? But in terms of working with the attorneys and understanding, what they understand about the process, I don't think attorneys necessarily need to know the difference between an EML file versus an MSG file versus a PST file, an NS file, and go on. But they do know that those are email files, and they do know that email files inherently have metadata fields. And they know that if we get a production and we don't have those metadata fields, that's a problem. So they know that, and they know that, all right, now we know what we need to do. They know that emails during the processing phase, while they may not know what's happening in the processing phase, they know that it's deduped globally or custodial wise. They know that emails are extracted and metadata is extracted and attachments are extracted. And when the attachments are extracted from an email, they become a child and a parent, and the whole thing forms a family. And if we get a production and we got an attachment or an email without one or the other, and it's not listed on the privilege log, that's a problem. So I think that understanding that whole process, and I know I'm focusing strictly on email at the moment, but on having them understand that and learning more and more about ESI and its data life and its cycle and where it comes from is it's important that they understand that, so that when they are called before the judge, or they have to have the uncomfortable call with opposing counsel to describe the issues, they know what they're talking about. And I think the attorneys in our firm have done that very well. I think they do a great job of understanding the process and understanding the why. Anybody can learn a product, but if you don't understand the process, it's not going to do you that much in terms of being able to explain it.
So what you said just brought to mind two separate thoughts. The first reaction was, this sounds a lot like law school issue spotting for lawyers. It's not knowing the answers necessarily, but it's identifying the issues you need to deal with.
Exactly.
It sounds like you've helped your lawyers and paralegals, I'm sure as well, be well equipped to do effective e-discovery issue spotting.
Absolutely.
The second part then is that as you were ticking off all of these different things, it brought to mind Atul Gawande and the checklist manifesto, and the notion that if you try to keep all of this in your head, that's, at least for me, it's not all going to stay there. If I don't write this, it just spills into non-existence for me. How do you handle all of these various pieces you've got going
on? That's a tough one. I think that I have a firm that's very supportive, and they provide support wherever needed. I think one of the biggest things that we do is after we go through a case, and every case has hiccups. Every case, something goes wrong, and no matter how well of a plan you have, something goes awry. I like to think that when we're done a matter or we've gotten through a really difficult time, that we take the time and we sit down and we do a what went right and what went wrong kind of scenario. And so that the next time we have this type of issue, we've been through this before, and we can kind of, remember that going forward. I think our firm does a really good job of reflecting on both good things that happen and things that may not have turned out so positively, and learn from that and move on, and then document. I think documenting is huge. Unfortunately, I do have a very good memory that helps me in some respects, in a lot of respects, but of course, I'm getting older, and senior moments happen more and more. But documenting is huge, and documenting, backing up, being able to defend what you've done or haven't done, being able to basically be able to go back and recreate and replicate what you did, and being able to stand by how you got from point A to point B.
So in the 5 minutes or so we have left, I would be remiss if I didn't ask you to at least touch on two growing areas of concern: privacy and cyber.
Those are definitely areas that are growing, and areas that our firm is really starting to get knee deep in. I think that as e-discovery technologists move forward, they're going to get brought more and more into the cyber and the data privacy arena, because I think there is a little bit of overlap there. We understand a lot of the technology that happens, and we understand when something goes bad. You know, I mean, unfortunately, we're in a day and age that we have all this wonderful technology, but we also have people that like to exploit it and do bad things with it. Trying to protect our clients' data is huge, but also working with clients to help them protect their data. And then in the event that they do have a breach, we're there to help them, or an incident, a security incident, we're there to help them get through it, migrate through it, close up any gaps, and then work with remediation.
One final question, because I have the time to ask it. And I haven't asked this of anyone for a while, but it's my crystal ball question. That's okay. There's no wrong answer. You are now looking into a crystal ball. You're looking at the future of e-discovery. And this is a magical crystal ball where the rules of physics are suspended, where anything is possible. What do you see in the future for e-discovery? You know, the perfect future of e-discovery. What would it look like for you?
Wow, I haven't thought of that. I hope I'm around to see it. I guess I think working in an environment, or working. I don't know. You kind of got me stumped there a little bit.
That's because you're so, heads down in the weeds working on this.
I know. I'm just trying to think of it. If I say no more litigation, I don't want to be out of a job.
Well, let me put it a narrower way then. What would be your perfect e-discovery technology? The thing that could do anything you wanted. What would it be able to do for you? And never mind what's possible. That's not important.
I think that being able to better streamline and finding relevant data in a much easier way, right? I don't want to. I think that I don't want to say that we don't want to do eyes on review anymore, but eyes on review is tough. But you also need to be able to trust that what comes out, if you don't do an eyes on review, is still not going to be harmful in any way. I think that better, if we could develop, as technology is developed, finding better ways to streamline getting collections in, getting it without having to collect the whole kitchen sink and everything that goes with it. I'm sorry, George, I don't have a way to answer that.
Well, you've already described something that no one's able to deliver yet. That just go in and grab the data you really need, and then be able to be confident that you've got what you need moving forward without having to run into all sorts of challenges to how you've done it. That's already far beyond where we are today. That's something to aspire to, though.
Yes.
Well, Dawn, thank you very much for joining us today.
Thank you so much for having me. It was a pleasure.
Thank you. Dawn Poulson is the Litigation Technology Project Manager at McLane Middleton. I am George Socha. This has been eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. And Dawn, Thanks once again.
Thank you, George. Have a great day.
You too.